Yes.
Really good morning, my lords, good morning. Lady, I appear together with Ms. Lee and Ms. Brackley for the appellant in this case. My friends Ms. Renton and Ms. Campbell-Brunton appear on behalf of the respondent. My friends Mr. Gratian, King's Counsel, and Ms. Chokri appear on behalf of the intervener, the Reunite International Child Abduction Centre. Lady, we're instructed by expatriate law, my learned friend for the respondent by Kingsley Napley,
Yes.
And the intervener by Mills and Reeve. I mention the solicitors simply when I make this preliminary point. Every lawyer in court today appears and has prepared for this case entirely pro bono.
Yes, for which we have noted, and we'd like to express on the record our gratitude. We're very conscious of the very significant amount of work that's involved in preparing any case pro bono, but this case has required very considerable efforts on everyone's part. So I thank
now we
all
hope
of you,
that,
but also the instructing solicitors who have to prepare the bundles and all the rest of it.
quite.
Never helped by us asking for extra submissions and all the rest of it.
All adds to the spice, my lady. We hope that you have a core bundle, a supplemental bundle,
Yes.
a probably overlong authorities bundle, skeleton argument, I think, separately on behalf of Reunite, then the short addendum submissions prepared by my friends, the respondent and us for the appellant, which we sent through yesterday, dealing with the RE-T case.
Yes.
And last and very much least, a timetable setting out what we hope to be the way to regulate today's proceedings.
Yes.
Now, I'm not sure, well, I know, because I would have read them had I had them. I haven't got a copy of Miss Renton's supplementary RE-T.
Well, I'm very sorry about that. I might have
No,
another.
I've got the appellant. Yep, I've got yours, Mr. Tyler, but I haven't got yours, Miss Renton. Do you think?
With the court, like 3 copies.
No,
You've got yours? I don't know.
Got
Mine doesn't seem to have reached me. So
No, not at all. Here's a copy.
thank you very much.
Pleasure.
I think I can guess what you'll say, but I'll reread it over. I'll read it over the short adjournment. Thank you very much.
In relation to the parties and the children, I'll refer to them with a deliberate degree of vagueness, if I may,
Yes.
given the need for confidentiality and the fact of this hearing being live streamed.
Well, I think, Mr. Tyler, I probably ought to make a specific direction that nothing must be done to identify the children or any of them.
Thank you. The respondent is the genetic and gestational mother of a number of children, the eldest of whom was born in 2008, the particular relevance of that date being that it is before the 1st of October 2009, being the date of coming into force of the relevant provisions of the 2008 Human Fertility and Embryology Act. The other children were born between 2011 and the middle 2010s. The respondent and the children, my lady will know, live and are habitually resident in one of the United Arab Emirate states. The slight rider to that being that the eldest child is at school in England. So wherever that child is habitually resident, that child was present within this jurisdiction at the point of the original application. The appellant was the civil partner of the respondent from...
Well, I was just wondering, we've got 2 quite big issues to deal with.
Yes.
On this, I think we're all familiar with the history of it. I was going to ask you how you propose to break down your time between the 2 issues that you're going to be addressing, the parentage issue and the jurisdiction issue.
Well, yes. I was going to deal relatively quickly with just I know my lords and lady have read the papers with a few of the background facts which we say are particular milestones along the way. Then I would intend to spend my time probably greater dealing with the consent and parentage issue than the other issue, unless I'm nudged to take a different approach. But when I come to the latter issue, I'll make it clear, as I have done in our addendum submissions, that we will commend the slightly provisional judgment of the Court of Appeal in RE-T very much to this court, and if I'm successful in that, then it won't take me a huge amount of time. but even if not, a lot of the arguments have been rehearsed before a slightly differently constituted version of this court in any event.
I think what my lord is saying is that we don't need an extensive setting out of the background.
Very well, thank you. Believe my lords will have seen the three grounds in relation to which we have been granted permission. Clearly, grounds 2 and 3 rather go together. Ground 3 being effectively a sub-part of ground 2 if we're not successful in persuading the court that a plain reading of the Family Law Act enables us to make good the point that we seek. So the key dates and events, if I can deal with them as quickly as I can then, just to set out what we say are the important points along the way. The fact of the civil partnership in 2006, the fact that after the eldest child was born in 2008, very shortly afterwards, a parental responsibility agreement was entered into and registered with the PRFD. And the court will have noted that the learned judge at first instance didn't accept the respondent's ex post facto minimisation of the reasons for the agreement and the registration of parental responsibility. That was, we say, have said and will say, is a very important pointer when it comes to unpicking years and much acrimony after the event, what happened and was intended at the various relevant points after the birth of that first child and the registration of the parental responsibility. The court knows that in 2010, further fertility treatment was undertaken and that was in the United States, specifically, and of some relevance, you'll see that we've said in our documents in Virginia. It's important, we say, to note that whilst that treatment was underway, the appellant, first of all, was looking after the eldest child, and secondly, flew out with that child to be present for part of the treatment. It's relevant, we say, that she was present, and you'll see the specific details in the chronology, but for a number of the births, going so far as to cut the children's umbilical cords. It's relevant, we say, that while she couldn't be present for later births, the reason for her not being present, accepted by the court, first instance, is referenced in his lordship's judgment. The court will have noted the children's names as registered. So the applicant's surname featuring in each of the children's names, the eldest as the second part of a double-barreled surname, for the other children as a penultimate non-hyphenated name in their names. And you'll have seen from the judgment that is accepted that important members of the appellant's family are also referenced in the other names given to the children. The christening, which you've seen referenced in the judgment and possibly other places, was November 2014. Whilst initially the respondent described the appellant as very much playing second fiddle in that, the video which we found and produced to the court during the hearing, and which the judge accepted as showing this, demonstrated two female parents equally involved, for example, one each taking up one of the babes in arms each to be baptized. The court knows that whilst there have been bumps along the way, it was the end of 2014 that saw the relationship concluding and a decision made by the respondent to move with the children to the Emirates. It's clear, and seems to have been accepted by the judge, that agreement was reached in relation to the children spending significant periods of time with the appellant post-relocation. And that those significant periods included significant stretches of time, for example, over the summer holidays. The letter in October 2015 sent by the respondent to the appellant's employer, I'll take the court to in due course, but we say is an important milestone along the way. In 2016, the civil partnership was dissolved. In 2017, there is the order describing the children as children of the family and making a notional maintenance order against the appellant. The court knows that, as had been agreed, very significant periods of time were spent by the children with the appellant until in 2020 things broke down. The appellant spent a very few days with the children in December 2020. That was the last time she saw the eldest child. She spent 1 day with the younger children in December 2021 and has not seen any of them since. The court knows that our applications were made in February and March last year, and the forensic history thereafter is set out in the papers. One other point, just before I come to the meat of the appeal, important we say to emphasise another aspect of the case. It having been agreed between the parties as an alternative to the expensive and potentially time-consuming exercise of instructing an expert, that the state of the law in the relevant state in which the children live is as described at page 23 in my skeleton. A, same-sex relationships are criminalised by the laws of the Emirates. B, a non-biological same-sex parent of a child is not recognised as a parent by the laws of the UAE. And C, a non-biological same-sex parent of a child has no locus to apply to the personal status court of the relevant Emirate state in relation to contact with the child or other aspects of parental responsibility. The clear relevance, we say, being that unless the English court has jurisdiction, to use Lord Wilson's words from Re B, these children's welfare would be beyond all judicial oversight. So, moving to our ground one, the question of parentage and in particular consent.
Could we, before we embark upon that, just for complete clarity, understand whether there is any relationship between ground one and grounds 2 and 3 in terms of either principle or practical effect?
Given that the judge found the children to be children of the family,
yes.
Then subject to the in connection with point, which is grounds 2 and 3, locus would vest in the appellant.
Right, so your success on the children of the family point is all you need for your jurisdiction?
Yes.
So in effect, just conceptually here, we could perfectly well be dealing with 2 separate appeals, heard on different days and separated by whatever metric one wanted to devise. So there's no read across at all between the 2 issues?
No, not necessarily.
That's helpful, thank you. That's what I was understood.
The statutory provision is set out, and I can't see it, is the court working electronically or on paper or combination?
Electronically for my lord.
There seems to be a growing tradition that the printed number, even though sequential, is different to the electronic number. So I'll give both and hope that in future we do better. Page 27 printed, 29 electronic.
So which printed? 27?
27.
Perhaps, would it be, if you're referring to your skeleton arguments, perhaps if you just went by paragraph numbers,
Certainly.
then you wouldn't be trying to do the juggling act.
Certainly, paragraph 35 sets out the wording of section 42 of the HFEA, which is a curiously worded statute, one might think. Note that the wording has remained virtually unchanged since the 1987 Family Reform Act, which was the precursor to the 1990 HFEA. And although the possibility of another woman being parent wasn't present in the 1990 Act, the wording in relation to a father acquiring parenthood in the 1990 Act is exactly as this. And of course, the 87 Act followed the 1982 Law Commission report on illegitimacy and the 1984 Warnock report and a fair degree of debate in Parliament. the mischief, it seems, at which the 87 Act was particularly aimed was the unpalatable prospect, doubly so in the 1980s, perhaps compared to now, of illegitimacy of a child born by the then emerging phenomenon of assisted reproduction. But it looks as though, from our researches, the wording has remained virtually unchanged from 87 to 90 and entirely unchanged from 90 to this statute.
What's the section in the 1987 Act?
27, my lord.
Section 27. Thank you. And then it's section 28, isn't it, in the 1990 Act?
Yes. So the current section in section 42, cases in which woman to be other parent, woman in civil partnership or marriage to a woman at time of treatment. If at the time of the placing in her of the embryo or the sperm and eggs of her artificial insemination, W was a party to a civil partnership with another woman or a marriage with another woman, then subject to section 45, 2 to 4, the other party to the civil partnership or marriage is to be treated as a parent of the child unless it is shown that she did not consent to the placing in W of the embryo or the sperm and eggs or to her artificial insemination, brackets, as the case may be. So when I say perhaps it's a slightly oddly worded statute, it seems or may seem slightly curious today, in a way it might not have done years ago, that the test references one adult consenting to or not consenting to something being done to the body of another adult. Consent, perhaps more typically, relates to something done to oneself or someone over whom one has agency. A second curiosity, perhaps, is that it's the specific final medical procedure to which consent, or in relation to which consent or the absence of consent is considered. So not to the process as a whole, or perhaps, as might be more relevant, to the consequences, i.e. consent to the fact of a legal relationship being created. And thirdly, curious, although the reasons are clearly established in the tracking through the previous statutes and the reports leading to them, it's proof of the negative which is required. That negative, once proved, displacing the presumption, if it's proved to the extent that it does. So those oddities, being as they may be, of course, the law is as it is. Other words, perhaps, about consent as a concept, before I turn to the section. If explicitly expressed, formal and informed consent for something is required, that's one thing. One can see if the form is signed. One can receive evidence as to whether somebody replied yes or no to the question, do you consent to X or Y? One can receive evidence as to whether that person was of sound mind, whether they understood the concepts being explained when they did or didn't give consent. Once consent becomes a simple question of fact, falling short of, stripped of formal requirements, it becomes more complicated, we say, from an evidential point of view. The process of determining whether or not it was present, or in this case, if it was not present, being more complicated. The issue and the evidential process and inferences to be drawn, we say, will depend largely on situation and on dynamics. So the issue would be very different as between strangers, as opposed to those who know each other very well. Very different between those whose affairs, financial, emotional, sexual, whatever, are entwined on an ongoing basis between those who are separate. So those in relation to whom, on an ongoing basis, there are issues which require consent or not, as opposed to those who come together simply for a particular transaction. In the context of a marriage or civil partnership, of course, parties fall into a way of existing, a way of being, a way of operating, which suits them. So it's in those circumstances that the possibly hard lines in some circumstances between acquiescence, consent, etc., can be seen, are rather vaguer. So looking for a moment at the President's definitions in paragraph 36 of my skeleton, which are taken, of course, from Re G. The President says this, for present purposes, I'm content to adopt, with some small adjustments, the submission of Miss Gray as to what these cases demonstrate. The intention, so number one, the intention of the 2008 Act and its predecessor, the 1990 Act, is to provide certainty, which is why there is a presumption. We agree with that. Two, Section 42 of the 2008 Act creates a rebuttable presumption that consent exists in cases of marriage or civil partnership. The presumption can be rebutted by evidence which shows that consent has not been given. Three, once evidence to counter the presumption has been led, the presumption cannot be used as a, quote, make-weight. So even weak evidence against consent having been given must prevail if there is no evidence to counterbalance it. And four, a general awareness that treatment is taking place or acquiescence in that fact is not sufficient. What is needed is consent, and this involves a deliberate exercise of choice. I add that whether a person did not consent is ultimately a question of fact. The reference to mere acquiescence there not being consent, of course, we can't disagree with. On the other hand, we wonder whether that quote, or that inference from the previous cases comes from a case, I don't think it's in the bundle, perhaps wrongly, but the case referred to in the previous paragraph of my Lord Justice Jackson, sitting at first instance of M and F and H. When this was said, I find that Mr. H acquiesced in the AI that took place at the first meeting, but that it has been shown that he did not consent. His failure to vocalise his objection or to have taken active steps to prevent the AI could only amount to consent if they were the outward signs of an inward consent. They cannot convert something short of consent into consent within the meaning of Section 35 of the Act. So, outward signs of an inward consent, we say, particularly in the context of an intimate relationship, a civil partnership, a marriage, people who day to day in a million different ways have transactions with each other of whatever sort, are something which need to be looked for.
Well, could we just rewind on paragraph 26 of Re G to see where your submission, as it were, runs into the analysis or collides with it. Under subsection 2, the second sentence, the presumption can be rebutted by, the President there said, evidence which shows that consent has not been given, or not been given, as he puts
Yes.
it. It might be more correct to say that it can be rebutted by proof that consent had not been given.
Yes, or by evidence that hasn't been given, which is sufficient in weight to displace the presumption.
Well,
exactly.
Big proof on the balance of probabilities.
Yes.
Well,
Yes.
so,
And this,
sorry, I just want to take this down. Because I think you somewhere take issue with the fact that as soon as you produce a bit of evidence, the presumption goes, and you just start as if it had never existed.
right.
That's not something which you seek to support.
Indeed. And this is what we will say when I come to the judgment, was one of the areas into which the first instance judge fell. Because first of all, there is the presumption, and the counter evidence has to be of sufficient weight. But secondly, of course, and this is the point I'm laboriously trying to make, in the context of an intimate and ongoing relationship, there are perhaps 1,000 other facets and facts which will assist the court, in fact, in working out what evidence there is other than the presumption, which militate in favour of there being consent or the absence of the lack of consent.
Well, is it other than, or is it reinforces the presumption?
Yeah, well, quite, yes.
And your point about the nature of the relationship means that if a couple are living together as a couple in the full sense, then the dichotomy between acquiescence and consent, as you say, um, although they are two different things, knowing that somebody is doing something on behalf of you both may amount to consent, whereas in circumstances where you did not have that close relationship, it wouldn't.
Quite.
Simply because that's how life operates for couples.
Well, quite. Well, I can think of a dozen mundane examples within a marriage of buying a car or the shopping or whatever else, where if the couple weren't a couple, the fact of consent wouldn't be present, but because they are, a far lesser degree of communication is necessary in order for it properly to be inferred that there was consent to effectively a half-spoken, half-unspoken course of action.
Yes, it may be pedantic on my part, but following that up, for little 4, a general awareness that treatment is taking place, or acquiescence, those really seem to me to feel each is different from the other. And for myself, I would probably in my head see them as numbers 4 and 5, but they're not the same.
They're not the same. And of course, they don't actually square completely with what Justice Butler Sloss said in the Leeds hospital case when dealing with a similar point, which is in fact that the husband, as it was in that case, doesn't have to go along with every part of the treatment.
Yeah, I think we were both juniors when
Yeah.
we did.
Name in front of
Season
yes.
6, but that relates back to something else. The problem there was that he consented to
something different.
He fully consented to the use of the right genetic materials, not the
Right.
wrong genetic materials. So the point that I was seeking to tease out is that there will be some issues on which, for a couple, it's impossible to be agnostic. That you may say, well, you're going to do shopping, I don't care if you get this or that. But if somebody is engaged in a trip for IVF, then it's not something that's easy to understand the other party to the marriage or the partnership being agnostic about.
Well, yes, this is perhaps where we come then to the oddity of the fact that the non-consent is referable to the act of insemination.
Well, I wanted to ask you about that, because it was your second point of the odd parts, which was the specific medical feature is what consent attaches to. But are you suggesting that if somebody knows that their spouse or partner is going for IVF treatment, that they need to know exactly the mechanics of the IVF treatment? Or is it sufficient that they know that they're going in order to seek to have a baby?
The latter. And that...
Right, so that's why the specific medical feature does not, on your case at least, involve knowing the science.
Quite.
Precisely.
Quite.
I mean, it might be important, as it were, to know who the genetic material was coming from, in a general sense. But whether it was one form of assisted reproduction or another specific form of assisted reproduction, on your case, is not fatal to whether there is or not consent.
Well, no, and that's perhaps why it's important that A, there's a presumption, B, it's proof of the absence of consent that's relevant. So if I go to buy the car with my spouse's knowledge, and her only expression of interest is this blue one, she probably hasn't not consented to my buying X type of blue car or Y type of blue car, unless I buy one which is 10 times more than was ever contemplated. Now, I use a deliberately mundane example because this is the language of the act is the non-consent of a specific act. But if it's the proof of the non-consent that's relevant, one has to look at the entire transaction. So if it is, so it is why in this particular case, we reference as particularly important the fact of the registration of PR for the first child. So within a month of the child being born, there is a family, they're civil partners, and the partner who wouldn't otherwise be able to acquire parenthood because the law hadn't changed, has parental responsibility. in those circumstances where there is certainly on any view a degree of combined planning, even if one partner is the more intimately aware of the details than the other, it's far easier to prove consent or far harder to disprove the fact of consent, even though the exact procedure, as my lord says, wasn't pre-known. What if there had been a formal written agreement to an active insemination on Thursday the 4th of May, and there was a power cut at the clinic, and it was 2 days later that it happened? It becomes silly to look for specific consent, which is why there's both a presumption and a requirement of a proof of negative, we say.
The negative, it's not consenting is not the same as objecting.
Quite.
And I think from your submissions, you're saying looking at Sir James Mumby's formulation, you say that the presumption is a substantive element of the process, and that's why you were submitting that the evidence has to be sufficient or of sufficient weight to displace that presumption.
It is. Yes, so point one we say, yes, it is. The presumption itself carries some weight, so any evidence of non-consent clearly would be enough. But secondly, the danger and the trap into which we say this judge fell is having found, we say it isn't actually what he thought it was, but having found that he accepted the respondent's evidence that the appellant did not explicitly consent, he then pretty much gave up there. Whereas, in fact, a proper survey of everything else would have put into context that finding and also added even more weight in conjunction with a substantive presumption on the other side of the scales. Of course, the G case, as in fact most of the cases, was that sort of case where it was common ground that the civil partner shouldn't be deemed the parent. In that case, the civil partner from whom the mother had separated provided a witness statement clearly saying she wasn't involved and didn't consent. And there'd been one of the manifold mistakes at the clinic, clinics generally, at this particular clinic, which required Sir James to rectify difficulty. And in those circumstances, it was fairly straightforward, I suppose, to produce and apply this test. I have evidence of non-consent in the form of a statement from the separated civil partner. Everybody wants a certain result, and hence the decision we have. Similarly, in the case my Lord Justice Jackson cited, where I referenced the acquiescence earlier, it was a case in which the husband didn't consent, as was found, to the wife's ongoing, unofficial, as it were, unregulated, artificial or possibly non-artificial insemination by a donor, which donor subsequently sought to evade the consequences of parenthood. Those are those sort of cases where problems need to be resolved by the courts. This, we say, is a very different sort of case. On any view where a civil partner, the non-gestational partner, is significantly involved in the process, although not as involved in organisation as the gestational partner, where on any view, it's common ground that at the point of, before, at the point of, and after the birth, that other civil partner is extensively involved in caring for the children. But ex post facto, years ex post facto, there's an attempt effectively to deny the status of parenthood. And in those circumstances, perhaps a rather more nuanced and subtle approach to establishing the existence or not of non-consent is needed than the simple test might lead a judge to take. It's in that latter sort of case that we say it's the peripheral evidence. I don't mean peripheral in the sense that it's not important, but simply doesn't go directly to the question of do you X person consent to Y insemination. It's the peripheral evidence which will assist the court in determining the dynamic, what in fact the parties intended. If one could go back in time, pause it and say to one of the parties, what do you think is happening and what do you think about it? it's that evidence which allows the court to unpick that.
In a case where there are clinics and regulations and forms, then clearly the word consent fits quite neatly into a context where if you're going to show your consent, you're going to be required to sign a form. In a case such as the present, where there isn't that process, is there any distinction to be drawn between the statutory word consent and the colloquial word agreement?
Well, perhaps even more complicated is the fact that we're looking at the absence of either.
Well, exactly, but I mean, just taking in a non-clinic case, non-UK clinic case, is our consent and agreement effectively synonymous?
Well, I think we would say yes. If one was to draw a distinction in a clinic type case, when the presence of consent might need to be proved, then the question of the degree to which the consent is informed, etc., even advice taken about consequences might be relevant. But of course, that's the exact mirror of this statute, which is to presume that, not only is the consent, but to presume that parenthood follows unless it's proved that X person didn't consent. So in those circumstances, given that it's without the benefit of lawyers at the time, without clinical involvement at the time, what was or wasn't in the mind of a lay party, I suspect that there would be very little to choose between consent and agreement. And with the perhaps
Why are we doing that?
Sorry, just a moment, please. Just resolved a dispute.
I see.
Very minor dispute.
Thank you.
Which didn't rely on any presumptions.
Can I just ask, sorry, why it's in my mind, the what has to be established? It's shown that, because coming back to your evidence sufficient to displace the presumption. So if you were to say, what does that evidence have to demonstrate? It must demonstrate did not consent. What is the difference between did not consent and consent?
Well, I think that would be difficult to define in the abstract. I think it would probably be a distinction which is resolved simply by the process of the judge framing and determining the question. So, question, is it established on a bunch of probabilities that the appellant in this case did not consent to what happened? What evidence is there tell me in each way?
But where you've got a presumption, there's a presumption of consent.
Yes.
So the evidence to disrupt that presumption needs to be of non-consent.
The evidence, well, A, needs to be of non-consent, and B, it has to be sufficient to tip the balance. So in a case in which a finely balanced case, that's where the presumption and by secondary to the presumption, the location of the burden of proof comes to the assistance of the judge at first instance.
I'm not sure, I just wonder about what my lady said. I'm not sure that the presumption is a presumption of consent. It's a presumption of parentage, unless. So I think the two may be slightly different. May not have any practical difference.
Well, yes, that must be right. The presumption is of parenthood, and the balance of the burden of proving the absence of consent is on the person asserting the absence of consent.
But can we just come back to, you were seeking to frame a question that a court might usefully ask itself when putting this section into operation. And it's really, is it established on the balance of probabilities that the spouse or civil partner did not consent?
Yes. So yes, that's the specific question, and the need for nuance, we say then, is in establishing the circumstances and the type of evidence which assist with that question when it's the absence of consent that needs to be proved in the context of, by definition, a spousal or civil partnership relationship.
Yes, the nuance you're talking about is the assessment of the evidence, not the test. There's no nuance in the test. It's on the balance of probabilities is not consent. It's how the court approaches the evidence, which takes account of the relationship, the nature of the relationship, other features, a sort of broad analysis of the context.
Is that there's no nuance in the specific single sentence, single question test as formulated by my lord. The difficulty comes, as always, when a judge with best of intentions then puts a slight gloss on that, giving one or two or three or four rules and helpful pointers. Which pointers, which rules, which glosses, and how many times has this been said in the Court of Appeal or the Supreme Court, then lead to someone falling into error, when in fact they should simply, the judge, be asking themselves the simple question.
Well, can we, in that spirit, as it were, just trying to tease this out, but I think you've already agreed that the question is not, is it established that the spouse or partner objected?
Yes,
But that would be a different question.
wholly different.
Are we able to create further, shed further light on what did not consent means by means of the question?
I hesitate only, my lord, to avoid falling into the same trap all over again, of then seeking to redefine a question, given that the number of scenarios potentially to which it relates are just so varied. I call to mind Lord Wilson in Reed B, congratulating me for reminding him not to put a gloss on the concept of habitual residence and then giving half a dozen rules which may or may not assist decision makers in the future, which of course immediately became a new gloss for new decision making.
There is, as my Lord's question points out, that the expression "did not consent" is not entirely easy in some respects. And so, for example, one could say that the question is not, is it established that the spouse or partner communicated a lack of consent? That's not the question. And this case law, in fact, my Lord's case that I referred to earlier, in which the donor father tried to insert that as a further part of the test, was expressly dismissed by my Lord. So it's not can it be proved that they consented, it's not can it be proved that they objected, it's not can it be proved that they communicated lack of consent. It is quite simply no more and no less than the test that the Lord formulates, taken from the statute, even if the statute's imperfect. And the need for nuance, we say, comes not just from the type of evidence, but also from the fact that because it's an absence of consent that's needed, if I consent wholeheartedly to a course of treatment undertaken by my wife or civil partner in a different country, but I can't go there to be with her when it happens, it's unlikely that I'll know exactly what procedure's taking place on what day. Let's say it's a novel form of treatment or something. So if the test was, did Mr. Tyler consent on this day to this particular act of insemination, then it'd be difficult to say yes. But given that I've consented through words or actions or otherwise to the procedure, to the question, did Mr. Tyler not consent to that act, the answer is far more likely to be in a negative. No, it cannot be shown. He did not consent. And that perhaps is the relevance of it being a negative that needs to be proved, given that by definition, it's not, well, except in the most obvious case, perhaps with a donor in person coming to the flat, it's not a single act on a single day.
It's a process, a course of treatment, a course of behaviour that's being undertaken with, if it's accepted, a common goal, then almost certainly an absence of non-consent.
Similarly, the question is not, is it established that the spouse or civil partner did not express consent? So it's neither express lack of consent nor express consent.
Nor, in fact, arguably, is the state of mind of the gestational partner determinative of the issue, may be evidentially helpful.
Yeah.
As has been said throughout the cases, it's a question of fact, albeit that the fact often won't be one that's discernible in black and white with a signature under it, but one which has to be inferred. And given that it doesn't have to be expressed or written, still harder for the judge, has to be inferred as to what was going on inside somebody's head at a particular time. But exactly why we say it's the surrounding facts and the behaviour before and afterwards that enable the court to focus on that artificial snapshot of one moment in time.
Is that a base on which to look at what the judge made of this?
Well, yes. Just before that, I wonder if we could look at my paragraph 39, please. Which sets out a number of factual matters which we say are relevant. There were detailed discussions between the parties. Now, I quite appreciate that the judge made the findings he did that my client was less involved than the respondent, but on any view there were discussions. That as a matter of fact, the children were conceived during the civil partnership. The PR agreement, we say, is very important when looking at the subsequent children. The presence, and I'll come to what the judge rather oddly, we say, made of this at the birth of children she could be present for, and her active involvement in the birth of those latter children where she could be there. The visiting after the births for which she couldn't be present. The very, very significant amount of contact that was agreed post-separation. The names I've referred to already, and what the witnesses at the time, what the witnesses who were present at the relevant time said about the contemporaneous opinion of what happened. And then in relation to the criticism that if you had consented, or if you hadn't not consented, your name would be on the Virginian forms, we point to the fact that there's no space on those forms for a same-sex partner. That not being possible under Virginian law until later. We point to the subsequent relevant, the subsequent behaviour which we say is relevant. And I quite concede that the further after the birth one goes, the less relevant that is to determining what somebody's state of mind was at the time. But the names, the way that the applicant was described in later treatment, the letter to the employer, and I've quoted it there, but I can take my...
Do you want us to look at that?
Please, it's at page 538
Supplementary
of
bundle.
the supplemental bundle.
Thank you. A different page.
538, supplementary.
538.
Supplemental, I have as a...
That's, I've got an article,
Yes, mine's an article.
an internet article.
And it's supplementary listed on. Mine's an article about the appellant.
I'm very embarrassed to learn an hour into appeal, we've got different bundles. It's Exhibit 11
Fine, we can find
to a
out.
statement.
That's just a little further on, thank you. Five stick two. Thank you.
562.
562.
I'm sorry. Very sorry.
Don't worry, but I'm never critical of bundles put together pro bono by busy solicitors and counsel.
So the second substantive paragraph, during our 10-year relationship, we had 5 children together as part of the, quote, custody arrangement, ... And then the final substantive paragraph, unusual request for special consideration as her time with her children due to the locality of the residency is extremely limited and very important to both her and the children. In relation to any specific piece of evidence, it can of course be said it was created for another purpose. It can be said of this that of course it's written in these terms because respondents trying to help appellants achieve an aim with employers. Cumulatively, though, we say that each individual bit of evidence takes on a greater import. And, of course, knowing what one does of the characters of the parties from the judgment of Mr. Hames, King's Counsel, one might think it relatively unlikely that the respondent would make herself a hostage to fortune post-separation in this way, if it were the case that the children weren't considered to be their children together, or, as in the final paragraph, her children. I've just been going through the list in our skeleton, and I got to paragraph 44. And as I say, I can see that with each year that passes, it becomes less relevant to the specific question. But in paragraph 45, then, the amount of time spent by the children with the applicant. 46, the nanny's recollections. And 47, then, other witnesses' recollections. And the court knows what Mr. Hames said about those. If one turns then to the judgment, which may or may not be at page 77 of the core bundle.
Give us the paragraph numbers, it's fine.
Before we turn, if I may, to His Lordship's express treatment of this question, there are a number of factors to which His Lordship made reference, which don't make their way into the, we say, flawed lists, which perhaps should have done. So, first of all, paragraph 72. Of the appellant, Mr. Hames said, she appeared to me to have a relaxed and laid-back personality. A third of the way down that paragraph, in places her answers were lacking in detail, it became clear to me she was not the organiser and even the decision-maker in the children's lives. Not able to provide a lot of detail about either the fertility treatment the respondent undertook or the management of the children's lives. At the bottom, over the page, I do not think that in cross-examination she knowingly told me anything she knew was false. It says a pretty important judicial impression. She told me, this follows that immediately, she told me that she and the respondent had made a joint decision as a couple to have children. She very much wanted children. She was able to give vivid evidence about her presence at the birth of elder children, and how happy she had felt. I accept she would have wanted to be at the birth of some of the younger children had that particular difficulty not intervened, I've no doubt that she loves the children and provided them with good care. So there you have findings about his lordship accepting her state of mind, referable directly to the children.
Well, in relation particularly to the first sentence of paragraph 73, are we to regard that as being evidence that the judge accepted?
Well, it follows immediately from a sentence which says, I don't think in cross-examination she know when to make anything that she knew was false.
This is in the context of assessment of the evidence
Yes.
of your client.
Yes.
I mean, is there anything later in the judgment which casts doubt upon the idea that this was a joint decision to have children?
Well, I don't think so, save possibly the, I'll come to it, the assertion that his lordship heard evidence which he accepted from the respondent that the appellant, quote, did not consent. But that's, which is an unusual...
Well, could we, I mean, if there is something later than paragraph 73, or indeed earlier, that casts doubt upon that, I think we should be shown it
Yes,
at some point,
yes,
by somebody.
yes. Lord 73 went on then to describe the happiness at the birth, the acceptance that she would have wanted to have been present at the other births, no doubt that she loves the children, provided them with good quality care. So language, all of this language of parenthood, we would say. And then paragraph 74 gives his impression of the respondent as being the more powerful personality of the couple, more likely to make major decisions. And halfway down, just below, I suspect she's very keen to ensure that the applicant is not able now to interfere with her own care of children and the management of their lives. To adopt the phrase used by Mr. Tyler, she did at times indulge in case building in the way she pushed her narrative.
But in this summary of the respondent's evidence, which springs from, no doubt, a great deal of written and oral evidence which we haven't needed to go through in detail, was it ever said that, was anything ever said to countermand or contradict the idea that this was a joint decision to bring children into the
She said
family?
Yes, she said it was effectively her decision.
Do we have that in the judgment, and if so, where?
Well, I don't think so. Well, no, I don't think so. That's the answer. And of course, as I've pointed out now, I think for the third time, having found the appellant not knowingly to have given false evidence, of course, perceptions can change with the passage of time. I quite accept. One wonders how it could be that that could have been accepted. The other passages I wanted to bring to the court's attention as not being in the lists, I'll take you to in a moment. Paragraph 91, well, this is referenced, but not to this degree. The respondent told me that she thought that the PR agreement would enable the applicant to care for the children if she died. She claimed not to have researched the effect of an agreement. I don't accept this, as the respondent is not the sort of person to enter into and register a formal agreement about her children without fully appreciating the consequences. On her evidence, she clearly knew the effect of the applicant adopting the children. So, the PR agreement having been entered into in relation to the elder child, and an explanation being given, which is I wanted to protect him in case I died, wasn't accepted by the judge. It was known that this would give the appellant all the powers and responsibilities that PR gives. And then skipping forward to paragraph 115, please. Having raised an eyebrow about the apparent lack of knowledge and opposition from the applicant and explanations of the respondent, His Lordship said, I accept the applicant's view of what names the children should be given as a factor in their selection, even though I expect the respondent ultimately made the decisions. Excuse me. I find it hard to accept that the respondent would have selected the surname of a best friend for a Christian name for all of the children if the applicant had not been part of the children's family. At that point, a series of points, we shrug our shoulders and just ask what is meant by a member of the family in the context of adults who are spouses or civil partners other than parenthood. Paragraph 117, what His Lordship made of the video of the christening is seen.
Sorry,
117. Third line, it shows a happy family celebration. It references the children being carried individually by each of the respondents separately, as I've already said. This is compelling evidence which supports the applicant's case, as the video clearly shows them both as equals in the children's lives. So just conjoining those two last points, you have them as equals. The reference in relation to the names and the PR as being part of the family, and just wonder what in fact His Lordship was finding. And a paragraph 124. His Lordship's treatment of the letter to which I have taken the court. He recognised the past role of the applicant in the children's lives, considered it important for the children for their relationship to be maintained, confirmed in the letter. So paragraph 131 then is when His Lordship begins his treatment of formulating a conclusion in relation to consent. I found the issue finely balanced, partly because of the way Section 42 is drafted. He references there being needed to prove a negative, that there was no consent to the conception. And then we say wrongly, or at least in an incomplete fashion, His Lordship sets out three possibilities contemplated by Section 42. And it's perhaps this formulation which led to the ultimate error. So possibility one, clear evidence that the non-gestational partner has expressly consented, perhaps by signing documents, so clear, yes. Possibility two, clear evidence that that person has positively objected to the treatment, perhaps because separated but still in a civil partnership, yes. And then possibility three, either W or the mother, as in this case, has produced some material which displaces the presumption and successfully proves the absence of consent. Yes, that's a possibility clearly. The missing is four, which is either W or the mother has produced some material which they claim displaces the presumption, but on analysis of the evidence, doesn't do so. So then in paragraph 133, and this picks up on my Lord Justice Jackson's point about the difference between evidence and proof. Mr. Hames finds that there is evidence that the applicant didn't consent, or that evidence is the respondent says at no time did the applicant consent. We say that that isn't in fact evidence of non-consent, simply one of the factors potentially which might lead a court in conjunction with others to find the absence of subjective consent is, if it's believed, the absence of the lack of consent being expressly communicated, or the fact of consent being expressly communicated. And that's then the next sentence is where his lordship falls into error in particular, perhaps because of the attenuated way in which Sir James Lumby's test is formulated in Read G. He can't, he says, use the presumption as a make-weight. Although I'm not directly concerned with the issue of consent treatment, A, it's relevant, yes, but nowhere do we read how it becomes relevant. And then paragraph 134, having carefully considered and weighed all the evidence, I conclude there was, quote, no deliberate exercise of choice. That is not the statutory test, but Sir James's gloss on that test, or one part of it, by the applicant, only an awareness or acquiescence. And then the reasons given, which I'll take separately, but it's important all 8 of these reasons are effectively negative reasons in his lordship's mind, so reasons militating against the possibility of there having been consent. I accept the respondent's evidence. He says that the applicant did not fully participate in the whole of the process. We say that is not a factor against, it's entirely neutral. Still more so viewed in light of the Leeds Teaching Hospital case, but especially also looked at in light of what we say is the need for the more nuanced approach to assessing evidence. I don't accept the applicant's account of her involvement. I found it vague and lacking in detail. An odd finding given what he said earlier about her evidence. But on any event, it seems to be accepted that she was involved to some extent in considering treatment, donors, etc. 3, no record or mention in the fertility records of having consented. In circumstances where it took place abroad, largely without her, and in a state in which there can't be a female parent. 4, satisfied that the respondent was quite determined to proceed with the treatment regardless, and without reference to the views of the applicant, we say entirely irrelevant to what was in someone else's mind. Subparagraph 5, and again, we just don't understand what's meant by this. The presence of the applicant at the birth of the eldest children and the presence of her name was a consequence of their relationship and nothing more. Perhaps his lordship means or meant that she was there simply to support her civil partner, but not intending to become a parent to the children. First of all, we can't see how that can follow from that. But for a gestational mother to include the name of the supportive civil partner in the children's names must mean more than simply a reference to the adult's relationship. Had she consented, she would have been registered as a parent on the children's birth certificates. Possibly not, but of course, if his lordship's right, that a respondent knew full well what was happening at each stage, there would have been no need for that. The fact of their marital difficulties at paragraph 7, irrelevant, we say. And years down the line, the fact of there being no question that the applicant would need to consent to relocation, we say irrelevant as a matter of pure logic, but also in particular when it comes to, or with reference to what his lordship said about the relative characteristics of these 2 women. But there we are. There are the 8 factors which his lordship said militate against, or enable him to find the absence of consent, or the absence, quote, of a deliberate exercise of choice. But then, though, rather oddly, his lordship goes on to deal with conclusions in relation to the, quote, charge of the family issue, in which he then disagreed with the respondent's assertion that these were not children of the family, and found that they were, and then gave his primary reasons, being 7 in number, which were all positive reasons militating in favour of the children being children of the family. Before I start going through these, let me make it clear why I'm doing so. We said that the difficulty was his lordship gave 8 reasons against consent. without considering any of the evidence which militated in favour of that, and then gave a whole series of reasons, which in fact, if they'd been put into the balance at the beginning, would militate in favour of there being consent or against there not being consent, but simply failed to include them in the balance. So in favour of the children being children of the family, number one, the PR agreement for A, and I do not accept this was merely to make arrangements for his care if the respondent died prematurely. So that being found in relation to the eldest child, how can that not be of relevance, even stellar relevance, when it comes to considering the question of the absence or not of consent for the other children's conception? Then this is another, number two, subparagraph where we just don't really understand his lordship's conceptualisation of different family relationships. While she may not have been a mother or parent, by virtue of the finding presumably 2 paragraphs earlier, I accept the applicant's evidence that shows that the applicant, the respondent, and the children were a family. The applicant effectively played the role of a step-parent. Her role was different to that of a best friend. So having promoted her above best friend, there's a distinction between step-parent and parent, when presumably a step-parent is a parent who can't otherwise claim the legal status of parent, but who otherwise exercises the functions of parent. So it's very difficult, we say, to see, first of all, what's meant by that. But secondly, if he's right, his lordship, that the appellant's role was different to best friend and was effectively, can I paraphrase that as parental in nature, then doesn't that go significantly to the question of whether or not there was an absence of consent at the point of conception? And if the PR agreement for the first child is then relevant to the question of non-consent for the next conception, the fact that the appellant acted qua parent to the product of the second conception is relevant to the question of consent for the subsequent conceptions. The children were given the applicant's surname and other names significant to her. So yes, clearly relevant to parent of the child of the family, but very clearly relevant to the consent issue as well. I accept the respondent's evidence that the applicant provided emotional support to the respondent and gave care to the children, but I reject her attempt to portray this as merely transactional in return to board and keep. So again, his lordship promotes the appellant above friend, supporter, someone transactionally providing support in relation to something, having categorised her in a parental role, but for some reason didn't include that in his list of factors, which should have been in both directions, on the question of consent and parenthood. So paragraph 5, the video of the baptism shows a family event involving the applicant and respondent and all the children as a family. Again, we can't see how that isn't obviously relevant and of probative value to the first question. And ditto 6, she wouldn't have agreed on a set amount of time with the children, and ditto 7, she wouldn't have written the letter to the employer in October 2015 if the applicant had not been part of the children's family. So we say that having, if one takes judgment apart into sort of separate jigsaw pieces, it may well be that the judge undertook the right exercises and made the right decisions on a micro basis about the evidence. But putting them together in order to answer the questions is where his lordship fell into error, and perhaps because he was simply applying a gloss in a case which, though it was about the same thing, was a very different configuration of a family, rather than, as perhaps my Lord Jackson indicated, asking the question, can it be established that the appellant did not consent to the conception of these children, and then analysing all the evidence for, all against, and deciding whether or not that burden has been discharged by the respondent. We say in this case, first of all, it's clear that he fell into error in the way he approached the task, but furthermore, it's clear when one adds back into the the analysis in relation to consent, all the other factors found, which I've taken you to at the beginning or the earlier parts of the judgment and in list number 2, that it was not established that there was an absence of consent.
What you're saying is he applied the wrong test, as we see it, paragraph 134, and the test he decided what was required was a deliberate exercise of choice.
Yes.
That's wrong in law.
Well, that's wrong in law, but even if one put the right test in there, or even one was...
Then he only put things on one side of the scales.
Yeah, even if that was the right test, he wrongly weighed the evidence in that. So unless there's more with which I can assist the court, that effectively is our case on ground 1. So firstly, that having teased out what the test from the statute is and having established that it's perhaps unusual, that is the test, there has to be a nuanced engagement with the evidence in order to try to work out the difficult question of what was or wasn't in somebody's mind at an unspecified or a very particular point in the past. That in order to undertake that in relation to this sort of relationship, it's quite different to, for example, the case that Lord Judge Jackson dealt with when you have a couple at home and a donor knocks on the door and things then happen. And that in the former sort of case, all of the evidence before and afterwards must be looked at in order to assist. Here, happily, it's not a case that will need to be sent back for someone else to look at because the evidence is overwhelming. Each of the factors piles on top of the others to demonstrate that it could not be established that the appellant did not consent to the conception of the relevant children. So unless there's more I need to say about that, I'll move, I think, to ground 2.
Clearly this is no more than dipping a toe into one part of the evidence, but I asked you earlier on what was being said about this by the respondent. And in the supplementary bundle, there are, I think, 2 statements which bear on this. I'm going to give a reference to the first one, which I'm afraid is not the same reference that you will have. It's 163 in the electronic bundle. So it'll be some way further forward in that.
What's the document?
The statement of the respondent.
That starts at page 169. What paragraph?
And it's the second page of the statement.
Page 170 in the...
And paragraph 4 appears at the top.
Yep.
So there's I don't want to go into this in detail, but just that we should understand what generally the respondent was saying about this. I haven't looked into what your client was saying about it, but paragraph 4 deals with the first child and the circumstances there. The next children, paragraph 8, and then the remaining children, paragraph 9. That was, as it were, I think, where this first appears. And then we look for more information in the second statement, which in my bundle appears at page 185, maybe 191 or thereabouts. And we have the first child at the bottom of paragraph 6 in the second statement. And then the next children in paragraphs, first 8, but then 9. And 10. and then the lost children in paragraph 12.
Yes.
Now, and going on, paragraph 14, for example. The first thing that strikes one is that there appears to be a difference in the nature of the evidence that's been given about the second group of children to the final children
Yes.
on the respondent's account. But one doesn't, I think, find particular findings by the judge in relation to any of those matters, does one?
Well, no, save to the extent that paragraphs, so no, not specifically, but save to the extent that paragraph 72 and 3 seem to accept the appellant's.
Yeah. But in other words, in a situation where it was by force of statute for the children's mother to displace the presumption, it's true that one doesn't find very detailed findings about some of these matters, but had the judge wanted to support a conclusion that the finding was displaced, it would have been necessary, I suppose, for him to say, I don't accept that this was a joint decision.
Yes.
I accept that it was really one party to a partnership. But freelancer.
Yes. I'm not can well imagine, given the expertise of Miss Renton acting for the respondents, that the applicant, as then she was robustly challenged in accordance with the respondent's case. Yet we read at the bottom of paragraph 72 the judge's determination that he didn't think he'd been told anything knowingly false. But certainly if his lordship had decided that the evidence was accepted in terms that there was an active absence of consent, so an active disagreement with the process, an expressed non-consent, then his lordship could have found that. And didn't. And instead fell back on the reasons through which I've taken the course.
Thank you, that's what I wanted to ask.
Thank you.
So, if I may then, grounds 2 and in brackets 3. In a differently constituted court, I'd probably spend more time on the bizarrely worded Family Law Act and the ways in which sections 1, 2, 2A, etc. Establish jurisdiction. But I imagine I don't need to do that here. It's most easily set out, I think, for my purposes, that's my paragraph 61. The court's power to make section 1(1)(a) orders derives A, from its having jurisdiction under the Hague Convention, or B, the Hague Convention not applying, but, and then one of the two criteria, separate criteria, is the matrimonial jurisdiction. So question 1, well, A, jurisdiction under the Hague Convention. Clearly, it didn't have in this case, because the children were happy to resident in a non-Hague country, but not in the UK. The question of exactly when the Hague Convention does and doesn't apply is the subject, or is to be the subject, of part of a judgment emanating from the court relatively soon, and about which there was a fair degree of debate in court. Much of that debate, I don't think, is relevant for these purposes, because presumably it's common ground that the Hague Convention doesn't apply, in circumstances where the children are neither present nor habitually resident in a country which is a Hague country. And if I'm right about that, I needn't...
I think it's the way B is phrased, the Hague Convention does not apply. So it does not apply in the sense of, it doesn't provide a basis of jurisdiction. Because if it provides a basis of jurisdiction, it applies.
Yes.
So it's that, what B means.
Yes. Yes, well, on any view, it doesn't provide a basis of jurisdiction.
Yes.
Well, not just in this country, but in any Hague country. So,
Yeah.
however one discerns it, these children are not do not fall within the ambit of Hague. So, if that's uncontroversial in this case, then Hague doesn't apply. So, question the making of the order arises in or in connection with matrimonial proceedings, and the Section 2A criterion satisfied. That is set out here, that they're proceedings for divorce, nullity, or dissolution, which, of course, they were and are continuing. Bizarrely, it's 40 sections later that one reads that continuing doesn't mean continuing at all, but the children are continuing to be children. But that is as it is. The Law Commission's report is set out everywhere. It's set out in the show, it's set out in T. I know the court's familiar with it. It gives the answer as to why the decision was made for jurisdiction to be retained until majority. At the bottom half of paragraph 4.8 and in paragraph 4.9. Ms. Renton queries the degree to which the court can... I know Melody hasn't read the supplemental submissions of Ms. Renton yet, but questions, both in that document and I think in this argument, questions the degree to which it's proper for this court to take into account the Law Commission report. We say it's quite clearly relevant to the court in discerning what the parliamentary intention may or may not have been. If this report were absolutely crucial in determining the meaning of a difficult phrase, or if we were relying on this report to persuade the court to give a particular phrase a meaning which isn't its natural meaning, then we could perhaps have those arguments. But in these circumstances, it seems to us that where this is simply a guide to interpretation, when in fact, without the report, one could perfectly easily reach the same conclusion, there's no need to do so. Don't forget, of course, that paragraph 42, though oddly placed in the statute, explicitly says that the temporal restriction on post-matrimonial jurisdiction does not end with the proceedings. It ends with the child reaching 18. So without anything else, it can easily be discerned from that that Parliament intended exactly, in Ronseal terms, what Section 42 says. In connection with, then, is the killer phrase, or was a killer phrase until my lord in the show used the word because, which then became the killer word instead. But either way, without wanting to waste the court's time going through all of the arguments in those cases, the starting point, better starting point, might be re T.
When he reclaimed the word.
Indeed.
Sort of. You want us to turn up re T?
Please, so that's when you will find at the end of the authorities bundle.
It's the last authority in the bundles.
I should be careful in claiming too much knowledge about the case, given who's on my far right and who's in front of me. But as I'm first on my feet, perhaps I'll look at it. So paragraph 9, one reads, of course, that the second issue is whether the judge was right in the first instance case to decide that the mother's application for orders didn't arise in connection with the divorce proceedings. We read in the judgment, for the reasons set out below, argument that the judge should have decided that the question did arise in connection with the father's divorce proceedings, so as to give the court jurisdiction. Paragraph 45. One reads that the first instance judge considered what the position would be if the 96 Convention didn't apply, and decided the mother's application was not in connection with the divorce, so that section 21b1 didn't apply. Adopted a broad view, noted the parties with the same temporal connection, but concluded the divorce has no connection to the children and their welfare. There was no overlap or link between the application of a Section 8 order and the divorce. Then one reads the submissions, notifications at paragraphs 47 and following. The legal framework at paragraph 52, with which the court is familiar. Paragraph 77, the court cites the same paragraphs of the 85 report that before we read this judgment we cited in our skeleton argument. And at paragraph 78, and of course this was before having the Brenton's arguments, said this: it's clear that the Law Commission, this is a bit below the quotation, did not intend to change this broad ground of jurisdiction, nor to limit it, principally for the reason given in 4.9, namely the impossibility of devising any general rules of the contrary effect, which would not sometimes operate against the interests of the child's welfare or against those of the parents. Paragraph 81, the court returned to the 85 report. With reference, of course, to the ability of the power to waive jurisdiction if the matter could more appropriately be determined elsewhere. And I'll come to that. My Lord adopted an approach championed by the previous president of quoting my Lord in Le Show in this judgment, at paragraph 182, quoting paragraph 187. But Le Show, of course, included the suggestion that the court should take a broad view in relation to the in connection with question. In broad terms, the only factors there are those three factors. But the important bit, the reason the court can take a broad view is because the provision only applies if neither Brussels II Revised nor the 96 Convention apply, and because Section 2A4 balances the broad scope of Section 21B1 by giving the court the power not to exercise the jurisdiction. And of course, there are the later stay provisions in the 86 Act. It's right to point out, as I did in my addendum document, the last few lines of that paragraph, which make clear that this appeal was in prospect at the time. Mr. Bodie is cited, and in the second part of that quotation, the grim prospect of a coach with or without horses being driven through a jurisdictional scheme if the section is too broadly construed is raised. The other High Court treatment then of Le Show and Section 2A is dealt with such as Mostyn, such as Poole, and I know the court is very familiar with those cases. In paragraph 89, the Court of Appeal in T accepted that Mr. Poole was clearly right to reject the need for temporal proximity. And just as an aside after the event, it seems odd to inject, or to seek to inject, a criterion of temporal proximity when Section 42 of the Act is so clearly worded, of all the things that can't be a connection. When Parliament said that, one would have thought the temporal proximity was high on the list, but there we are. Justice Mostyn thought otherwise. His Lordship also thought Mr. Poole right to reject the need for a clear causal link. With all due respect, to require the facts giving rise to the present application to be fairly traceable to the now concluded divorce does not create a test which can be sensibly applied. We raised the same points before this judgment in our skeleton with a series of questions, asking effectively how one could possibly trace the subject matter, or track the subject matter of a subsequent child case to a previous divorce case. First of all, in any event, before the law changed, petitions being in relation to unreasonable conduct and children cases being in relation to disputes about parental responsibility. At paragraph 91, the Court of Appeal takes up, the point that we made, that post no-fault divorce, to seek to establish any link between a Children Act case and a divorce would be to throw courts into mindless and satellite litigation, whilst the parties, having had the benefit of a no-fault divorce, then thought about what it was in fact which caused them to divorce, and try to tie that in with the with the subject matter of the Children Act case. The court goes on paragraph 92 then, and this is the important part of the judgment so far as we're concerned, to consider that similar problems emerge from Poole J's preferred formulation. I struggle, said Lord Moylan, to see what connection there might be between the issues raised in the welfare application and the divorce proceedings. It would, with all due respect, create an opaque test for the purposes of determining jurisdiction, when it's not clear to me that is what sections 2 and 2A mean. Nor, I would add, can I see the purpose of imposing such a test when the court has broad powers to stay proceedings. And at 93, unable to find any suggestion that there was any intention by the introduction of those words to limit the very broad nature of the jurisdiction provided by section 42(1)(a). Further, the approaches in the above case would have the effect of restricting the broad application of sections 2 and 2A, would have the effect issued by the Law Commission report of creating a general rule to the contrary effect, which would not sometimes operate against the interests of the children's welfare or against those of the parents. And then the point's made that that would be difficult to reconcile with section 11 of the Act, and of course the conundrum there is that it's possible to conceive of a situation where a curtailed section 2A jurisdiction in combination with a section 11 prohibition on jurisdiction would mean that you had children habitually resident in the UK in relation to whom, because of where they live and where the divorce took place, neither court would have jurisdiction, which would be an absurd consequence, we would say. We add the adjective, but an absurd consequence of the narrower approach being taken. And at paragraph 95, that again the point that we've made separately, that this isn't opening floodgates, it's not driving a coach with or without horses through any scheme, because, number one, as we've seen at the beginning, this jurisdictional scheme only applies when Hague doesn't apply. If we're right that Hague applies when A, a child is habitually resident in this country, or B, in fact, in any other Hague country, then by definition, I'm slightly constraining that argument, but by definition, one's looking only at a case when the child is habitually resident in another non-Hague country, and there has been a divorce or dissolution in this country. So already limiting cases, but by definition, limiting cases to those in which there cannot be a conflict with the primary scheme being Hague. And secondly, of course, the power to stay means that if an unforeseen problem is caused, or if it simply doesn't make sense for the children case to be heard here, then the court has the usual forum grounds to make their decision, and they're pretty wide grounds in the Act. Thus it is at paragraph 96 that the conclusion is expressed. Again, it'd be wrong for me not to point out that the conclusion is expressly provisoed as being subject to any further arguments advanced in this appeal today, but that subject to that, the Court of Appeal felt that the simple approach to be applied is that those sections give the court jurisdiction when the parties in the proceedings are or were the parents of the child concerned, as at that point, that of course is defined, and that's the relevance of the child of the family point. That the proceedings are taking place or did take place in England and Wales, and that one or other or both of the parents seek a Section 11A order. So we, unsurprisingly, entirely associate ourselves with that conclusion for the reasons given in the judgment, for the similar but not identical reasons in our skeleton, and in fact for the similar but far more learned reasons given in Reunite's skeleton on the issue. All we would say, and I don't for a moment mean to belittle their erudition, but all we would say about the the new argument on behalf of the respondent, and then my lady hasn't seen this, so I wonder whether it would be fair and easier if I just asked my lady to read half a dozen paragraphs from those submissions. So Ms. Renton's submissions, starting at paragraph 7, through to paragraph 13.
So are we already familiar with the argument about Article 10?
Yes.
Yes, thank you.
Thank you. So, first of all, we associate ourselves with Mr. Grayson's assertion that it would be not just wrong, but an exercise in complete futility to seek to interpret two entirely different statutory regimes consistently with each other, but not least in circumstances when in fact they don't overlap. So we take issue with the analysis at paragraph 10 onwards. Proceedings between Spain and England concerning parents. Child habitually resident in Spain. Article 10, conferring jurisdiction in England, which jurisdiction ends at the point of the proceedings ending. So point number 1, the Article 10 prorogue jurisdiction exists only with the consent of both parties. Issue 2, of course it ends at the point that it ends, but the consequence of its ending is that if elastically the consequence of Article 10 is that jurisdiction which would otherwise vest in Spain vests in England. At the point that England releases the case, back it pings to Spain. So at that point, Spain has jurisdiction under Article 5, Spain being a Hague country. So at all points of that, Hague applies. It's by virtue of the application of Hague, the Article 10 exception, that there may be brief scope for proceedings in this country. It's by virtue of the case returning to Spain, the primary scheme, at the end of that, it's by virtue of Hague that that takes place. At all times, it applies. So we said there's no point in that at which the Family Law Act could give the court the matrimonial jurisdiction. So where is the scope for there being a conflict or an overlap? Again, back to the principal point, the reason why this isn't an exorbitant jurisdiction or a problematic jurisdiction, or we're not going to fall into conflicts with convention partners, is because, by definition, in what's otherwise an opaque act, the matrimonial jurisdiction only arises at the point that, however it's defined, the Hague Convention does not apply. The other points well made there, they are, in Moylan and Friends' arguments, I think we've probably preempted and dealt with in our principal skeleton argument. Just before I turn my back to those behind me, are there any other issues I can help the court with?
No, thank you very much, Mr. Tyler.
Thank you very much indeed.
Thank you. Yes, Miss Renton.
My lords and my lady, I've of course proposed to deal with ground one first, and wish to divide my submissions firstly into looking at some of the findings and the way in which the judge approached the issues of fact first of all, and then go on and consider the law and hopefully deal with some of the points that arose from the interchange with the learned friend this morning. First of all, it's right and hopefully not trite to observe that this is a very unusual case on its facts. This is a case involving fertility treatment through a clinic, where therefore the issue of consent had to be documented at all times by the clinic for all of the fertility treatment that was undertaken by the respondent. Secondly, it is an unusual case in circumstances where the learned judge accepted that the role that the appellant played was not the equivalent of my client's role, but was a step-parent in the very specific factual circumstances that he investigated at some length at trial. And his conclusion in my submission that there was a difference in this case between the issue of legal parentage under Section 42 and whether these children were children of the family, which was the locus, the gateway then into the Family Law Act and the Section 2A jurisdiction, was the right conclusion on the facts of this case, even if face value the court may have some concern as to the lack of overlap between those concepts. In terms of looking at what the judge actually found, in my submission it's important to just have a look at this because some of the things that my learned friend have said to you, in particular, he took you at some length to paragraph 39 and 40 of his skeleton, but those were the points made by the appellant at trial as opposed to what was found by the judge. And I'm sure my lords and my lady appreciate that in any event. But for example, paragraph 39A, I fear all of my pagination, I should say, is also wrong, was not accepted by the judge in terms of the detailed discussions point. In particular, paragraph 39H, you'll have seen the way that the judge treated the additional witnesses and the lack of weight placed by those additional witnesses on the judge, by the judge. And paragraph 40...
Sorry, just taking it.
Sorry.
You've gone to A, yes.
A.
You said the detailed discussions were not accepted by the judge.
Yes.
We'll come back to that.
Yes.
The next one was...
H.
Thank you.
The weight that was placed on those witnesses was low, despite what the appellant had invited the learned judge to do with that evidence. And then paragraph 40 was certainly not accepted and was very important when the judge looked at, I would say, the appellant's credibility and her changing case on why she wasn't on the fertility documents and why she hadn't consented on those documents. The findings that I say are relevant and led to the judge's unassailable conclusion on Section 42 are as follows. First of all, paragraphs 100 and to 101 that
We're
my
in the
client
judgment
was,
now. We're in the judgment now, aren't we?
You were in the judgment, forgive me. So in the judgment, on my, for what it's worth, on my electronic bundle, it's at page 25.
Paragraphs are fine.
Yes.
Right. Paragraph 100.
Yes. So paragraph 100 and 101, findings that my client was the sole owner of the biological material generated by the fertility treatment. And I would say crucially that the clinic had viewed her as the sole decision maker. So on the documentation, the respondent was treated as a single recipient of fertility treatment. And there was then an absence on all of the fertility documentation that was needed for all of the procedures that she undertook, the IVF and the IUI. There was no need for the appellant even to sign for consent.
But she couldn't. Could she have done anyway?
Yes.
So same-sex fertility treatment was provided for on the documentation.
Yes. Well, certainly one of the issues that had been, the appellant had various different cases on consent, which is set out in the judge's case. In the judge's judgment at paragraph 100, it might be easiest to look at it in that way. If you look at paragraph 100 and 101 of the judgment, you'll see the different ways in which the appellant put her case, none of which were accepted by the judge.
The judge decided that the appellants had not, he didn't consider the appellant had given evidence that she knew to be false.
That she, forgive me?
That she knew to be false.
Well,
So her evidence was that she thought she had signed the documents. So that was accepted by the judge, that she thought she had signed the documents.
well, that is one read-in when you look at the judgment overall. That of course he did also not accept a lot of what she was saying in relation to her involvement with the process and the donor's choice.
I understand that, but if her evidence was that she thought she had signed the documents giving her consent, and the judge accepted that evidence.
Yes.
Right.
I accept that. But in answer to Milady's question about how my client was treated because of the fact that she was from a same-sex relationship, part of her case, the appellant's, was in relation to the way in which they would have been treated, and in particular the change in law in Virginia that only happened later. And I would say that the reading of the judgment is that that was not accepted because he came to the view that my client was simply treated as the sole recipient without any rider to that as to why that might be. But all of these issues were explored in length during the course of the trial.
Rewind for certainly my benefit to explain what the situation, what's the setup in Virginia in relation at that time, at the various times, to the position of a spouse or civil partner in relation to the provision of consent for treatment?
Well, Lord, I'm not sure that I am best placed to give you that answer because this was quite a late feature of the appellant's case. And there was, for example, no expert evidence on this point. There was some evidence from the person who was in charge of the clinic, but not in charge of the clinic at the time. And there was therefore, I would say, and no doubt Moylan, correct me if I'm wrong, but a fairly broad point put that pre the change in Virginia law, the clinic would have just effectively sort of shut their eyes to the reality of the situation and just treated my client as a single recipient. but that was a case that was put by the appellant, but not in any great detail.
Yeah, but I mean, in the end, the burden of proof was on you. Yeah. So just thinking about this, you told us at the beginning of your submission that in relation to the clinic treatment, the issue of consent had to be documented at all times. Is what you told us. Now, is that so?
Well, that was my case. Yes, I mean that was my case at trial, and the appellant's response was what I had outlined, but it was thin on the ground in my submission in terms of the evidence that was.
But what basis did you have for saying that the issue of consent had to be documented? I had understood until you made that point that we were dealing here with an entirely different form of regulated IVF. Well, I say entirely different, but there was a difference between what we're used to in this jurisdiction, which is that you have to go through the consent forms gateway before you'll even get any treatment.
Yes.
And my understanding from the judgment, because the judge makes no point about this, is that the regulation is not of that nature
So
in Virginia, but I may be quite wrong about that.
yes, so my lord, the easiest way I think of dealing with this is to have a look, please, at in my supplemental bundle. It's 613.
Thank you.
This is evidence. She didn't prepare a statement, and there was a lot of discussion about that point at trial.
Well, what document?
And this is, sorry, this is an email from Sarah Crana.
Who is?
And Sarah Crana is the head of the fertility clinic in Virginia.
She came after the treatments, but
But
she was
she-
the head of the clinic that provided
Elizabeth
them.
Derbyshire.
Yes, that's right.
Crana,
So
Crana.
sorry. So
Is it an exhibit?
it is an
Can
exhibit.
you
It's
tell us which exhibit?
Yes, of course. So it's Exhibit 1 to a witness statement of Sarah Crana. And so her witness statement is almost right at the end of the supplemental bundle.
I see. 655.
I've got 614.
So
I'm so sorry, I
656.
don't know what's happening with imagination.
Is this date 28th of October 2022?
No, so her witness statement should be dated the 15th
You
of
know,
November.
the email that you're taking
Yes,
us to,
yes.
28th.
Sorry, yes.
7.
Let's see.
What should we be looking at?
In particular, well, first of all, if you look at paragraph, so my solicitors ask an array of questions, and then halfway down, over the page, on the second page of the email, she's asked to give her answers and to confirm various points. Point one is in relation to how my client was treated, which was as a single recipient. And point 2 and 3 is particularly relevant to my lord's point, because the assertion was as to how my client would have been treated because she was in a same-sex relationship. And Sarah Crana was very clear that even though my client would have been in a same-sex relationship, queried the duration of that relationship, the clinic was still willing, pre the change in the law in 2019 in Virginia, to treat same-sex couples,
Yes, but that's
and that the partner would have been expected to sign the clinic forms, this is point 3, if undergoing treatment together, and both intended to be
Yes.
parents.
But under our arrangements, if you are having treatment together, then you have to sign the forms together. But I'm obviously only looking at this for the first time, but it appears that the operation in Virginia is on the basis that you can either sign up jointly or not jointly, and it's
No, that's not right. So if you look at point 3,
it said would have been expected to.
Yes.
That's they've no business to be expressing an opinion of that sort. Unless the situation is, unless this is evidence that if you are going to be treated as parents, you must both sign up. That's the point.
yes, So
But
if they had
otherwise, you know, either you can go and you can go on your own, or you can go together. It's
yes,
up to you.
yes. So our point to meet the appellant's developing case on Virginia law was that if we, as in the respondent and the appellant, had entered into a joint decision to have this treatment and had shown up to the clinic saying, we're in a same-sex relationship and we're undergoing this treatment, the clinic would have said, here's the form that we need you both
Yes, so it didn't
to
have
sign.
to be documented, to use your... I mean, the consent did not have to be documented if they were going to be regarded as being the joint parents.
Well, the fact that we didn't have those documents and my client was treated as a single recipient was because of our case as to the fact that she was the one who had solely decided to have this treatment.
Yes, but where in the documents, because I know that in this we've got a number of clinic documents, does it tell us that if you're a couple, then the consent or otherwise of the non-childbearing part of the couple must be taken?
Well, that's what I say. Sarah Croner is saying with point 3.
Yes, but take us to a document, for example, that shows us that you have to do like you have to do here, which is if you're going to be treated together.
Well,
you
I
have
mean,
to give your
I only,
consent.
sorry, I didn't mean to cut across you.
No.
I mean, I had the fertility documents that we have were the ones that my client had signed, which were single recipient documents. So we didn't produce other sort of pro forma consent documents, but the basis of our case that was the subject of challenge at trial was that, much as in this country, if they were intending to have treatment jointly, they would have had to have signed a joint consent document as a same-sex couple, and the clinic would have found that acceptable even pre the change in the law in Virginia. And so, without going too much into it, although perhaps it is of some relevance, we then produced a formal witness statement from Sarah Croner. She was unable, despite strenuous efforts, to give oral evidence at trial. And we then agreed between us that, in the usual way, the weight that would be attached to it would be a matter of submission. But that was relevant evidence. It might not be particularly clear, I accept, from the judgment, but it feeds into Maud's point about the joint decision-making and what the findings were and what the findings were not, because the respondent's case squarely at trial and put extensively to the appellant was that this wasn't a joint decision-making process at any stage, and she relied on the fact that she was treated as a single recipient, and that she was treated as a single recipient because that was the intention, as opposed to the fact that she was a same-sex partner.
The judge deals with this at paragraph 134.4, 134.3. It's one of his 8 reasons on consent.
Yes.
That the point that he's making there is that she is not recorded as having consented, or mentioned as having consented, in the fertility forms. But with his understanding of the treatment programme there, the absence of a written document doesn't conclusively prove that she didn't consent. So it just strikes me that that's, when you say the issue of consent had to be documented, doesn't seem to be the judge's conclusion about that.
Forgive me, what I meant was forgive me, and maybe it was a clumsy way of phrasing it. The issue of consent had to be documented if there had been consent by the appellant for the purposes of the fertility treatment in the clinic. I accept the consent doesn't have to be documented for Section 42, and I never said otherwise at trial. But my point is that it was a very important piece of evidence, an important finding that went into the pot when the judge was then considering Section 42. And that he effectively, and of course my Lord knows that a judgment doesn't necessarily encapsulate every single point that was made or raised at a trial, but the issues in relation to Virginia law and Sarah Crana were canvassed at length. And so his finding was in that context.
But is the takeaway message for us that it was entirely a matter for the couple themselves or the individuals involved in the couple as to whether they presented as a single or as a joint applicant for treatment? It was entirely a matter for them so far as the clinic was concerned.
Yes.
All right.
Yes. And what I would say, and what I said at trial, is that if this really was a joint endeavour, leaving to one side for a minute what was a very contentious issue as to when the parties separated and so on, which had a real bearing then on the fertility treatment as well, and what was going on at the relevant times. But that if this really was a joint endeavour, then our case was that they would have shown up to the clinic as partners and they would have signed the consent documents in the ordinary way. And so the fact that my client was treated at all stages of the fertility treatment as a single recipient was not because she was in a same-sex relationship, but it was because she was the one who had decided to have this treatment and the appellant had not consented.
But I'm not seeing how this fits with it. But in relation to the first child, the appellant did go to the clinic.
Yes, but she didn't sign any of the documents. She went to the clinic once, but she didn't sign any of the documents at all, and he predates the HEFA in any event. But all of the other documentation is single recipient.
But in the case of the second children, as I recall, she stayed at home with the first child. So what was your case? That in order to benefit from this, you'd have had to travel alongside with the young first child. That's what you say would have been expected, is it?
Yes, I mean, if you're going to be in a relationship and you're going to enter into a course of fertility treatment with all the attenuating consequences of that emotionally, financially, and so on, then the absence at any time of having consented in circumstances where, from memory, we canvass being able to have a form emailed and signed in all kinds of ways other than being in person, because at various points from 2009 to 2011 the appellant wasn't even in the country, would of course have been logistically feasible. But my lord, of course, it's only one part of the picture, because into that pot goes the lack of knowledge of the entire fertility process, the donor, the lack of attending appointments, the fact my client was treated as a single recipient by her GP, and so on. But it is, in my submission, a powerful piece of evidence that she was always treated as a single recipient, and that there was absolutely no written consent at any stage where, in my submission, that could easily have been given if this really was a joint decision-making and it was intended that the appellant was a legal parent.
Just one more question, if I may. When you took issue with Mr. Tyler saying that it was of assistance to note that detailed discussions took place between the adults
Yes.
Before each pregnancy, and you say that was not accepted by the judge. Do you mean that the judge made no finding about it, or that the judge rejected that?
Forgive me, I mean that he made no finding on it. Yes.
Right, so not accepted is not correct.
Yes.
And what is the what is left of the issue of consent had to be documented is really what you say the issue of consent could have been documented, and you say would have been expected to be documented.
Yes. Yes.
Thank you.
But as I say, it's very much part of the picture. So in terms of other, I would say, important findings that the judge made when looking at the way in which these women had crafted their life in the decision-making process in what was a very lengthy fertility journey. There is paragraph 103, the lack of knowledge by the appellant, and the judge said a remarkable lack of basic knowledge of the fertility process. confusing IUI with IVF was one example. Not understanding why the decision had been made for IVF instead of IUI. Paragraph 104, again, a significant lack of knowledge as to why the donor for all 5 children was chosen. And I think my Lord raised earlier whether you had to have detailed knowledge in order to lead to an establishment of consent. I would say no, but these are striking factual features of this case in circumstances where the appellant's case was we were in a relationship throughout and this was joint decision making.
Isn't there a bit of a wood for the trees point arising on paragraph 104 that we're descending to considering what one adult thought they were choosing and what the other adult thought they were choosing. But, isn't the blindingly obvious point from this is that they were choosing? What are they doing looking at photographs of donors if they're not choosing?
Well, my Lord, it was a different point. Of course, you have to be satisfied that the judge, having surveyed a broad canvas and having heard 9 people give evidence and having not necessarily dealt with every twist and turn in a judgment, which of course he doesn't have to do, I would suggest, had then come to a very careful overall view of what it was in a very unusual case and the way in which these women had crafted their life and this fertility journey had been undertaken. But addressing the point, it was more than that. Paragraph 103 is about the fertility treatment. My submission at trial was that if you were in a loving relationship, your partner was undertaking a raft of IVF and IUI with all that entails, that you wouldn't even know the basics if this was joint decision making and you were properly part of the journey and consenting would be unfathomable in my submission. That was what I said at trial, was effectively what was accepted. Equally, the donor evidence was evidence right at the beginning, but the respondent provided very detailed evidence as to why she had chosen the donor, and our case at trial was broadly accepted.
They chose a donor together, it appears from this.
No,
but they gave different evidence about what they thought about the donor.
Well, the respondent's evidence was that she had some sort of initial discussions with the appellant and shown her and shared with her some information at a time when they were in a relationship. But the lack of detail and understanding as to why which the donor was chosen, which of course was a hugely significant decision, with all sorts of repercussions for your family and your children, all of that information was only known to the respondent. And our case at trial was that, again, if you were really in a relationship where this was a joint endeavour, given the importance of that decision, both women would know all about the donor. And the information that the appellant knew was incredibly cursory. And so that went into the overall pot as well, in terms of the judge's decision-making about the issue of consent. Equally, paragraph 105, the judge was clear, neither party suggested anything other, really by inference, than that my client would be the genetic or gestational mother. Again, part of the picture of her being the single recipient and being the one who was undertaking the treatment.
The judge also said, sir, that the applicant said that she wanted children, in the same way that he had set out her evidence that they made a joint decision as a couple to have children.
Yes.
Where does he address that evidence?
Well,
his observation that that she didn't say anything that she knew was false suggests that he accepted the genuineness of her evidence unless, you can see from the judgment, he rejected specific parts, like he rejected that she had, or those she thought she had, signed any documents. So, and as my lord has said, looks at photographs. Where are they? Where do they feature? Where do these elements feature in the judge's analysis?
Well, I accept there are parts where there is perhaps a lack of clarity about findings. That includes also, I would say, the chronology that was important, because my case was that from a breakdown of a relationship in 2018, an affair in 2008, forgive me, an affair in 2009 that was accepted, and the appellant then travelling 2009 to 2011 that was accepted. What that meant was that fertility treatment for all 4 younger children was in that context of effectively the relationship not subsisting. And that was a point that was bitterly fought at trial, on which there are not really findings by the judge that I can take you to in terms of what he says about that and what perhaps he doesn't say. But it perhaps would be a step too far to then say at certain points where he hasn't made a finding that that's because he ultimately accepts the appellant's evidence, as opposed to him just not taking a concluded view on those points.
But you didn't seek clarification, and you're not cross-appealing.
No.
Isn't the difficulty for you the fact that the burden is on you in this respect? That if you were running this case and one sees the origins of it in the statements that we looked at earlier, then it was really for you by one means or other to get it across the line, because that's what the statute says. And so doesn't it come to the same difference that even if we find that there are matters that the judge might have made findings, or indeed that he should have made findings about, that it doesn't really avail you, because the findings that you need are absent?
I would say that the findings that the judge made, which I'm taking you through deliberately, are sufficient for me to get home as such on the section 42
yes,
point,
that.
and that you have to bear in mind, as of course is almost trite law, that he hasn't necessarily put in every twist and turn in his judgment, but he undertook a broad overview of the nature of these parties' relationship and the dynamic between them when coming to that conclusion, having presided over a 4-day trial where the cases were properly tested at length. And so even if there is a lack of clarity, which arguably I would say cuts both ways, there is enough, I would say, for the court to not disrupt that factual determination under section 42.
You say a 4-day trial. Was it has at the head of it 14th to the 18th of November?
Yes, so we had one day where he wrote his judgment. So we were meant to be in Leeds for 5 days, and we ended up in Leeds for 4 days.
You were actually in front of the court for 4
Yes.
days. Thank you.
Yes. So going back to the findings that I say are crucial, there is then the next point at paragraph 107 in relation to the GP's understanding. Forgive me. First of all, there's the point that my client was the next of kin of the children. And then 106 is the GP's understanding that she was a single parent, and that was clear from the medical records that were considered at length at trial. And the GP had written a letter, in fact, that was part of the evidence, and he was also clear that he was aware of the appellant, but he had still treated her as a single parent. That evidence wasn't particularly challenged at trial either. And then, and this doesn't make its way into the sort of consent findings section, but it clearly in my submission is a very important finding. is paragraph 72, which my learned friend took you to before of the judgment, where my client was found, or forgive me, the appellant was not found to be the organiser and the decision maker in the children's lives.
That's not an uncommon state of affairs, is it?
Well, again, perhaps the judgment...
Plenty of couples where there's parents who, one parent is the organiser and the manager, and the other one swans along in the slipstream, often to the intense irritation of the organiser, she says with feeling.
May potentially be the case in some relationships, my lady, of course. But this was, and again, perhaps it's not necessarily apparent from the judgment because there was an array of evidence about lack of involvement or even being on nursery forms, lack of understanding of schools that were being chosen for the eldest child,
But we
and so
haven't,
on.
as my lord says, we haven't got a respondent's notice.
No.
And I really think that given that we haven't got a respondent's notice where you're saying all these following facts should have been found, you know, when you're starting to dip into lots and lots of other evidence that we don't have the judge's findings about, it's quite difficult. I completely appreciate your submissions that you actually don't need all that, and presumably that's why you didn't file a respondent's notice.
Yes, quite.
Because you're content with the findings there are. But I think it's more helpful if we do concentrate on the findings that you say supported the judge's decision.
Yes.
Rather than us veering off into areas where evidence was heard but the judge that we don't find anything in.
Yes, of course. I appreciate that. But what I would say is perhaps if you took that in isolation, Milady could of course make that point, but it has to be coupled with all of the other points that I've already set out, because the overall view that the judge reached, which in my submission he was entitled to reach on the facts of this case, was that my client was treated as a single recipient. She was on the fertility journey alone, because she was the one that was undertaking that treatment irrespective of any wish of the appellant. And so that was why
Well, I understand your point.
he ended up with his conclusion. Thank you.
Can I just, while we're looking at this, ask one question? This looks as though the judge thought he had to undertake an analysis, a detailed analysis of the whole of the relationship, looking at the degree of involvement as an organiser, decision maker in the children's lives, in order to decide the Section 42 issue. Was that urged on him as being necessary, or did somebody say it's a more overarching, general view? You don't need to descend into this level of detail and actually embark upon what has similarities to the regrettable years of dependent divorces.
So, of course, it was my side who raised whether there was even locus for a Section 2A jurisdiction and whether the children were children of the family. And the point that it was raised, there wasn't a huge amount of evidence.
So the judge needed to decide that issue as well as the Section 42 issue.
Yes, absolutely.
And so they overlapped from the point of view of evidence.
They well, not so much because, well, sort of, because at an earlier stage when everyone was more focused on Section 42, there was more streamlined evidence about consent.
I understand. Yes.
And then when I said it might be that there's no gateway even into Section 2A because they might not be children of the family, it led to
Right.
a more
Understand. Thank
wider
you.
inquiry.
Yes.
I think paragraph 87 of the judgment touches on this, on my Lord's point, when it records the submission that you made.
Yes. And then the last important finding I would say is paragraph 83. So, of the judgment, forgive me, you'll see that the learned friend the learned judge talks about the fact that he heard from 4 witnesses from the appellant. You can see his treatment of that evidence. And then he says in the last sentence of paragraph 83, strikingly, they never recall any child or either party referred to or call the applicant mum. And with one exception, don't recall the use of the term wife.
We don't have, at least I haven't picked up what they did call.
They would call her Steph.
Yes.
And then, of course, we go into the findings that were made. There is a difference, I would say, between the judge's exercise under Section 42 in terms of considering the rebuttable presumption of consent and the judge's different exercise in considering whether these children were children of the family. And although there was an evidential overlap, they are different in my submission.
Would that be a convenient point?
Yes, of course. I'm grateful.
Would it be right for us to understand that they called your client mum?
Yes.
Mr. Renton, I'll take away your supplementary written submissions. Can read to you and read them over the shorter journey.
Thank you. I'm grateful.
Very well. 2 o'clock, please.
All right.